Hello and welcome. Hello, my royal lovelies, and welcome back to the channel. Welcome to my home. Today, I'm going to be doing a kind of follow-up video. Let me just pop my coffee down. I'm going to be doing a follow-up video to the video I made about the Lady C rumours that something is going to happen in the springtime, and she believes it's to do with potentially the revelations that Harry and Meghan may have used a surrogate for at least their first pregnancy. Anyway, I'm not saying that is true or not true, but what I do want to talk about is the legalities of it. So in that previous video, I spoke about what I felt might happen, and that is, of course, applying the law, that surrogate pregnancies currently, as the law stands, would not be able to inherit titles, styles, and be in the line of succession. However, I did think and feel that that potentially could change should the situation arise. Now, I found, by the way, a lot of people agreed with what I said, but I actually found that this was debated on Wednesday, the 13th of March, 2013, and I will leave what I'm reading from now linked in the description box, so have a look there for it. It is on the UK Parliament website, so it's all official. Everything here is 100% verified, true, accurate. There is a record of everything everyone says in Parliament recorded, and the succession to the Crown Bill was debated Wednesday the 13th of March 2013, and I have the entire transcript. It makes for very interesting. It's very long, so which is why I'm not going to read all of it, but it was a very big kind of discussion, debate about it. Now, I think what struck me immediately is the fact that this was debated at all. It shows, you see, with UK law, remember, we do not have a fully written down constitution, like, for example, they do in other countries, including the United States of America. The closest we have to a written down constitution is Magna Carta, and that was kind of just to slightly limit the monarch's power, if you like. So what we do have in the UK is an ever-evolving system of laws that kind of shape up where we are today, which actually means that the UK constitution, if you like, can be very flexible, can be very mouldable, and actually can be quite fluid and can kind of move with the times. So back as far as 2013, people were debating whether or not the rules that we have currently in place would be sufficient now and into the future. The whole debate, just the fact that it's being discussed kind of proves that people are thinking, should it be changed? Should it be amended? There could be situations where, where surrogacies, adoptions could actually take place with members of the royal family, and should there be provision? Now, this is what Lord True said. Like I say, it's a very long-winded document, so you can read it at leisure. But he said, "My concern arises from the security of the 17th century term heir of the body, the governing definition for the right to succession, as it might be constructively tested in the courts in modern conditions, namely the emerging legislation for same-sex marriage and the techniques of surrogate childbirth. On the first, it will clearly be lawful for a monarch or an existing heir of the body to enter into a same-sex marriage when that act becomes law," which it now is. Remember, this was from before. "After all, one hesitates to imagine the circumstances in which either Clause 3 of this bill were used to frustrate an intended same-sex marriage, a novel interference with rights, as others have pointed out. thereby denying that person succession to the throne, or indeed where there was no intervention and the marriage was accepted in some of the realms and not others. So basically what they're saying is, for same-sex marriages, that would not bar somebody from ascending to the throne. So, for example, if Prince William turned out to be gay and wasn't with Catherine anymore, he could still ascend to the throne. So, in circumstances, the then Prime Minister would find himself in the uncomfortable position of Lord Salisbury in 1890, when Queen Victoria suddenly became enthusiastic about a passionate, possible Catholic marriage for the second in line to the throne. I do not want to take this issue further. I simply lay on the record the potential for conflict. However, I do want to pursue the issue that follows, inevitably, from the possibility of a lawful same-sex marriage, from that and indeed the position of a royal couple who cannot conceive a child. There follows the question of whether a child could be argued in the 17th century language to be an heir of body. I pointed out in committee that the relevant statute refers to an heir of the body being defined from one person, not from both in a couple. In committee, and in a most courteous letter to me, my noble and learned friend Lord Wallace, whom I thank for his handling of the bill, which has been outstanding, said, only a natural-born child of a husband and wife can succeed to the throne. If that is so, and it has always been understood to be the position, those words would also exclude any claim to becoming a monarch made by the future child born of a queen, an heir of the body of a queen, who was not engendered by the sperm of a consort, even though that would-be heir might have been from an egg of the queen, carried by the queen, and born of the body of the queen in a lawful same-sex marriage. We all agree that this is common law. I simply ask whether the common law is proof against any claim to a right that might be entertained in the future, even in the European Courts of Human Rights or anywhere else. It need not arise directly in the case of an existing heir, but in a less proximate person who then, by accident, became heir to the throne. So this is all thinking about the future. It hasn't happened in the past, it hasn't happened immediately, it hasn't happened in the here and now, but it could in the future. So this is true. The current law does say that basically a child born of a surrogacy has to be born of the body of the spouse, the female spouse of the sovereign. And of course, we can get into all the different ethics around different genders as well. But basically, there is no provision for anything else other than this kind of 17th century setup, which they're acknowledging is very, very outdated. Basically, the upshot from all of this is that they were not going to make an immediate change. I think they were all satisfied that the current provisions are okay for the here and now, but that it could be challenged, for example, in the Court of Human Rights. So if Lady C is correct, and we don't know that she is or not at the moment, there's lots of debate about it, lots of conspiracies going on, lots of photos of things that went on, video footage things. Anyway, lots of debate. If it turns out that there was a surrogacy involved, that might explain, this might explain why it was kind of hushed up, maybe even kept kind of hush-hush by the palace as well as Harry and Meghan, because they knew that the current laws do not provide for the children born of surrogacy. Personally, I think that the laws should just be updated to reflect modern times. I think as long as the child, the embryo, is created via the sperm and the egg of the parents, of the royal parents, then I think that is perfect. To me, that is of body. What you're really doing by saying that the child has to have been born from the royal couple, physically born, i.e. birthed, then what you're saying is it's the birthing that is more important than the genetics. And I think in modern times, that's not going to be the case. I think they will change and update the law to reflect that what matters is that the child, the embryo, has been created via the sperm and the egg of the parents, of the intended parents. Now, in the UK, the law is still weird. There is currently potential changes afoot, but they haven't gone through yet. So with surrogacy, let's just say the surrogate, the surrogate that's either had an embryo implanted or they've used the sperm of the intended father to make the baby. If that surrogate has a partner, a married partner, then on the birth certificate, that husband will be the father. You then have to go to court to get a parental order that transfers the parental guardianship, if you like, to the real parents, the intended parents. And then all those documents get amended. So if Harry and Meghan had a child by surrogate, you would have expected the birth certificate to have followed British law and to have the surrogates and the surrogate father as the initial parent. So we don't know 100%, whether or not anything potentially could have been fudged. There is a distinct possibility about that. We have seen Lilibet's birth certificate, but I'm not quite sure if the laws and rules and regulations are quite the same from the States. I'm not entirely sure on that one, but that's just a little bit of background about UK law. So there we are. We're kind of left at a point where nothing was really addressed. It was debated, but the situation was not updated or resolved. Do I think it will be in the future? Yes, I do. In fact, it may even be debated in the near future, especially if things in the media are picking up holes in the current law. Like I say, the heirs of body is a 17th century term that refers to a time when they could not have foreseen, those people could not have foreseen the fact that we could be having adoptions, that we could be having embryos created and then implanted, that surrogacies could ever have been a thing. So the current provision is very 17th century. Like I say, as far as I'm concerned, it should be all the components of the embryo should be of the royal couple rather than outside influences. How that would affect Harry and Meghan going forwards basically depends upon a willingness to make amendments to the law. If the surrogacy rumours turn out to be true, the law could be changed. Letters patent could be issued to still include Archie and Lilibet in the line of succession. But I still feel that children that are adopted probably wouldn't happen to them. Like I say, I think letters patent could be issued that could mean that they could still have titles, but that they probably wouldn't be in the line of succession. So there we have it. We've looked at the debate. Like I say, I've left it all linked so you can go and have a really good read of it. Lots of interesting points were raised, lots of references to the actual law rather than people's opinions. So yeah, there we go. Thank you for watching this video. If you have enjoyed it, please give it a big old thumbs up. If you have any further questions, then please leave them in the comment section below. So from me, for now, mwah to you all, and goodbye.